saw Robert carry out a crowbar and to make sure our stuff was not missing. He said he would not do it because it was a civil, not a criminal. At that point, we left, or he left. We went in the house and noticed that about 50% of the stuff that I still had there was gone. Now, when she says junk, I don't know how anybody can consider a love seat and couch leather with 4 recliners junk, and huge entertainment that holds a 52-inch TV is junk. I mean, her classification of what was left as junk is, I had a pink Aurora collectible dish set that was still there. I mean, it wasn't junk. There was a lot of items left, which we've included 3 pages of items. I had 8 bins of Christmas decorations still in the garage. Recently, we had an auctioneer come in and just kind of glance over the stuff. This was before she took anything. He said that after his fees, which run between $1,500 and $2,000, that there would still be about a $3,000 check that would come to us after the bankruptcy was done if we were to sell those items. So her classification of junk is a little misinterpreted there. But at this point, I went back. At that point, we got out what was left, except for I had not gone back and cleaned up. I had gone through some bags that she threw as garbage, and I needed to go back and clean that up and get some empty boxes. I went back, and all the locks had been changed again. So at this point, I'm not there, but a lot of some statements that Bruce has just said and some statements that I've seen in here are inaccurate, and he admitted to not really sitting down and talking to his client.
Ms. Honig, it sounds like your clients are much more concerned about what you and I would call the personal property versus the real property.
Correct, Your Honor.
And that everything I've heard so far, I've seen the pleadings, really raises an issue of should the Ms. Sweet should she have taken out the personal property as she did, and if she did it improperly, there'd be an issue of damages for the loss of that. On the other hand, Mr. Havens, on behalf of his client, raises the issue of probably have a pending sale for this property, 829 East Walton, that they just want to complete that sale. And so, in some ways, you're talking about personal property, Mr. Havens is talking about real property, and if there's no more personal property at 829 East Walton, there's very little that it seems to me that you can do about that today in terms of if it's gone, it's gone. And likewise, I can't do anything about it either. If there's something more there that could be moved in a day or so, then that's a different story. And it looks like one of your clients wants to talk to you, so if you want to just take a short conference, but I'm just trying to figure out, is this a case where we should let the real estate be sold and then argue about the value of the personal property, what happened to it later? Or, and if it should be later, should it be here or in state court, or where should it be argued? Because I see 2 different parties with 2 different concerns, and I would hate to have the Sweet adversely affected for no good reason. I hate to have your clients adversely affected for no good reason. So that's what I'm kind of puzzling over. Do you want to talk to your client just for a second? Because it looks like he's got something he may want to tell you.
Okay, sure. Thank you.
You're welcome.
Your Honor, my primary concern with this was that the notice said that their personal property would be deemed abandoned, and that's the main objection, is their stuff would be deemed abandoned if this notice is considered valid. They don't necessarily have an objection to the sale of the real property, but they don't want their personal property considered abandoned.
Right. I understand that. And that's what I'm hearing from everything you're telling me, and what one of your clients has told me directly. I haven't heard anyone say, by the way, we want to buy this property, or we have a purchase agreement or anything like that. It's basically we're concerned about our personal property that's there.
Well, originally, we had an agreement for a lease to buy it, which
Right.
is why this has been drawn out so much, is that she just kind of went and sold it. You know, I was making payments towards it. $400 of my monthly rent was to go towards the purchase of the property, but when she said, here, you need to buy it now, I don't have a means of buying it, obviously, right now. But if we would have carried out the agreement in 18 months, I would have had the means. And that's why, and then they file this notice, they only send it to the trustee and to her, who is not representing us in the eviction process. They didn't even send us a copy to say, hey, you've got 7 days to get your stuff out of there. You know, so I don't, you know, the possession of the property, one, they've already got it, two, they can have it, let them sell the house. But this piece of paper, this notice of intent to sell, is what took our property, and it should be brought back.
Right. When you say your property, you mean
My personal
your
stuff.
personal property?
Yeah.
Understand.
May I address that issue, Judge?
Let me ask Ms. Horn, anything more you want to say right now? Because we'll go back and forth for a little while longer. I can just tell that already.
No, Your Honor, I think you understand what our objection is.
Sure.
Thank you.
Mr. Hayes.
I mean, it's not that, hey, it's the first time I've been to Flint, and you know me, I don't like coming to court.
Right.
It's not that you scare me or, you know, I don't like to see you, but it's a waste of my time.
Well, when you said circuitous route, I thought, you know, it is a different trip from Mount Pleasant to
It is, and Linda let me take her car, so I actually had some fun.
I see.
As far as the personal property goes, okay, there was never my intent to do anything other than get the house cleaned up so we could get it sold, okay?
Mm-hmm.
And what transpired regarding all of that, I mean, I would assume, when you compare what was on the petitions and schedules to the list, okay, the trustee may reopen the door to that too, because there was a 1-carat gold marquee ring, or diamond marquee ring, and a man's diamond ring, and there was all sorts of what appeared to be very valuable things that weren't scheduled. So maybe the trustee will reopen the issue on the personal property. All I care about is being able to sell this house. That's all I'm here for, and if that time comes to fruition, we'll have to deal with it. It's just the urgency of the matter is possession so we can sell.
Right. Mr. Hayes, what exactly do you want from the court in terms of, you want an order of some sort that says essentially that your clients have the right to sell the real estate at, I just lost the address, 829 East Walton Road, Mount Pleasant, Michigan? Is that
Yes, and that there's no stay in effect.
Would you have any problem with that order being signed by the court with an additional condition that issues regarding personal property, and we distinguish between real property and personal property, of the debtors will be resolved at a later date and time because
Absolutely, no problem.